Granny flat agreements. These granny flat arrangements are a very common part of elder law. Essentially, they are any arrangement whereby the adult child and the parent decide to cohabit together in one way or another on a permanent basis. This could include the parties jointly purchasing a property together. It could include one party contributing financially to the other in order to develop the property to provide either a separate self-contained accommodation or to provide self-contained accommodation within the dwelling itself. These are increasingly popular for many reasons. Sometimes granny flat arrangements will also come with an obligation on the child to provide care for the ageing parent for the rest of their lives. It's really important to have any such granny flat agreement put in writing at the outset. This ensures that the parties are both on the same page in terms of what the agreement actually entails. It means if down the track there is a dispute, a change of mind, or some other factor, the parties have the agreement that they entered into at the beginning to remind them of their rights and obligations. Unfortunately, all too many times, the parties are reluctant to enter into a legal agreement because they feel that it's family, so why should lawyers get involved in family business? Unfortunately, we do see when these granny flat arrangements do go wrong. Granny flat arrangements can go wrong in many ways. We have seen adult children simply just be sick of the arrangement and push their parent out of the property within 18 months. We have seen parties undertake a caring obligation and after a number of years simply give up on that caring obligation and push the parent out to live with other siblings. Sometimes the parent does not go on title and the parent loses all their money and has no security of tenure for the property. If the couple divorces, then the property is at risk through a property settlement. If there's any bankruptcy involved, again, the property could be at risk. If the ageing parent needs to go into aged care, they no longer have liquid assets in which to fund a refundable accommodation deposit. These are all factors and issues that could be avoided if time and care was taken at the outset of these arrangements. Another factor that is really important, if there are significant financial contributions, that the party making those contributions should actually go on title to the property. Yes, this may attract a stamp duty charge, however the stamp duty is a small price to pay for some security. Another factor of granny flat arrangements is it's really important that all the parties update their wills. This isn't particularly where there are other siblings involved, to make sure that there are no disputes after the death of the parent or any of the parties in respect of the property. So granny flat arrangements can be very useful, but care should be taken at the outset to enter into a formal agreement. Each party should have a separate lawyer in order to make sure they're getting independent legal advice. So if you're thinking of entering into a granny flat arrangement, contact us today, LS Legal, for all your needs in relation to elder law. Thank you.